Hey everyone, it's Attorney Matthew Legan Sanchez here. Are you going through a difficult or abusive relationship and you have a restraining order that involves children and possibly CYFD? If so, let's uncover how the process is going to look and what you should expect. In New Mexico, a restraining order of protection can be filed whenever there's an act of abuse against a family member or household member that poses an immediate threat of danger. If your ex or a household member has acted out in violence or anger and poses an immediate threat of danger to you or your child, then you can file a restraining order, and potentially a temporary restraining order will be entered, and it can grant you temporary sole legal custody until a hearing is held. Most acts of abuse that involve children also involve CYFD. And when CYFD is involved, there may be a safety plan that puts the child with one family member or another family member like a cousin. They may not actually do that and they're just doing an investigation. But ultimately, CYFD can become involved, and they're ultimately very crucial at restraining order hearings. Most parents that are going through a separation or divorce and there's violence involved, when a restraining order is filed, that restraining order involves a child. And the child is going to be based on an act of abuse. One parent's going to file a restraining order. The act of abuse may be legitimate, and there was a legitimate act of abuse that poses immediate threat of danger to the child, or it may be a strategic maneuver for one parent to try to get the leg up in a custody or visitation case that's upcoming. But either way, it's a common action that happens when there's an act of abuse or danger, domestic violence involved with a relationship and children. CYFD often becomes involved whenever there's allegations of abuse or neglect, if there's allegations of domestic violence, there's allegations of drug use, there's allegations of an unsafe home environment, leaving children unattended. CYFD usually is going to become involved because one parent or a school worker will contact CYFD. And when CYFD becomes involved, whenever there's a restraining order, CYFD is going to testify at that restraining order hearing. And their testimony is going to be very influential to the hearing officer that ultimately is going to decide if an order of protection is going to be entered. At the restraining order hearing, when CYFD is involved, CYFD usually is going to be subpoenaed. They're going to show up to the hearing and they're going to testify if an act of abuse occurred. Now, if CYFD testifies that an act of abuse occurred and that one parent poses a danger to the other parent, to the child, it's highly likely that an order of protection is going to be entered if those two things are said. Act of abuse, danger to the child. On the other hand, if CYFD shows up and they say, no, the claims are unsubstantiated, there's no danger to the child, maybe they even say there's coaching going on or something along those lines, probably the restraining order is going to be dismissed. Maybe it'll get entered, but more likely leaning towards getting dismissed if they say that basically there's no active abuse, no danger to the child. So what happens when there's a hearing and CYFD isn't prepared to testify? Usually what's going to happen is the hearing is going to get continued to another day. Under statute, the initial hearing has to happen within 10 days. Now that 10-day requirement is usually extended for good cause, and good cause usually means they just don't have enough time to hear all of the restraining orders within 10 days. But when CYFD is unavailable or not complete with their investigation to make recommendations, the hearing officer is usually going to continue the hearing until CYFD has the ability to complete their investigation and then testify as to active abuse or danger to the child. So when an order of protection is entered, let's say that the hearing officer, based on the testimony of CYFD, all the evidence, believes that an act of abuse occurred that places an immediate threat of danger to the child. When that happens, the hearing officer has jurisdiction, which is another word for power, to decide custody and time sharing for 6 months. And for this 6-month period, the hearing officer can decide if there's communication, if there's visitation, maybe if it's a significant act of abuse, one parent gets visitation, but it's supervised through an agency like APN or Neutral Corner, maybe a family member. But if an order of protection is entered, the hearing officer is going to have 6 months of power to decide what the appropriate time sharing is. The hearing officer's ability to decide custody and time sharing for 6 months can heavily influence a DM case. So there's a DV case, meaning the restraining order, and then there's a DM case, which means like a divorce and custody case, something that's going to be long term. But when a restraining order is entered in a DV case and there's time sharing and communication entered, that can become the status quo that then impacts long term the DM case. So there can be potentially long-term ramifications of a restraining order being entered and how that can impact a custody or a divorce case long-term. Because of the long-term impact of a restraining order with custody or divorce, it's really important to take your case seriously. You can handle your case on your own without an attorney, but you at a minimum should talk to an attorney. You should get the facts, you should see what hearing officer you have and how they usually rule on issues of this nature, find out what's going on with CYFD, but understand the impact that a restraining order being entered that involves a child, how that can influence you long term, can influence you for years and years. It can start off your case on a bad footing and you're just going to limp along for years and years potentially. So it's very important to treat these cases seriously, even though it's an administrative hearing, even though it's in front of a hearing officer and not a judge, even though the petition is handwritten by someone and it may have spelling errors, it may sound really bad, it may look very generic. For all of those reasons, don't be deceived to take it lightly, because a restraining order can really haunt your divorce or custody case. Do you still have questions about your restraining order that involves children? Do you have questions about the CYFD process? Do you have questions about how a restraining order can impact your custody, your time sharing, or your divorce case? If so, you need to talk to an experienced attorney. Talk to me, Matthew Ligon Sanchez. I've been handling restraining orders for over 13 years. I have experience all across New Mexico. I've handled divorce and custody cases all across New Mexico. I have the experience that you need to get to the bottom of your specific case.